Welcome to the Sarasota County Elder Care Channel, brought to you by Mike Levine and the great folks at Home Instead of South Sarasota County. Today's guests are Brady Scherer and Annette Boone, attorneys with Isfording, Bechtold, and Scherer.
Hi, welcome to the Elder Care Channel of Sarasota County. I'm Marianne Gordon with Home Instead, and I'm here with Brady Scherer and Annette Boone from the law firm of Isfording, Bechtold, and Scherer here in Venice, Florida. Welcome.
Good morning, how are you?
We're very well, thank you. Today we're going to talk about estate planning. Annette, can I start with you?
Sure.
Okay. I've heard that the most important estate planning document you can have is your will. Why do I need a will?
Sure. If you don't have a will, this means that your assets will pass per state designation, meaning this could exclude any loved ones or companions and, of course, any charities that you would like to gift to. Additionally, a will is a great organizational tool. It helps facilitate the process of distributing your assets to whom you intend.
Great. So what kind of things can I put in my will? Can I say, okay, my daughter gets my house, my son gets my car? Are those sort of the typical things you would put in a will?
Of course, your will directly addresses these issues. Speaking of your home, for example, you could leave this outright to an individual, or you could give somebody the right to live in your home for their lifetime and then have remainder beneficiaries.
Okay, I think I'm kind of understanding to have somebody live in my home for the lifetime, that means the home wouldn't be sold. It would just, this person would stay there, and then after their death, the home would be sold.
Correct, and there's lots of flexibility where you could give them the right to maybe sell the home or not. It's just whatever you desire you can create and put in your will.
Okay, so after I die, what happens to my estate? Who takes care of giving my daughter the house and my son the car?
So the individual is called your personal representative in Florida, who administers your estate and is responsible for that. They will do the administration process as your will may pass through probate or sign off on any necessary documents. And ultimately, they will make sure that your property is distributed to the individuals per your will's designation.
All right, so I need to appoint a personal representative. Can I appoint a family member to do that?
Yes, family members are commonly appointed. However, the most important goal is to just make sure it's somebody who's trustworthy. And so whether it be family or not, that's the overall objective. People, in addition to family, have appointed either their attorneys, their CPAs, or financial wealth advisors.
All right. Well, I also heard that there's other documents I have that I need to have. And one of them, I'll address this to you, Brady, is an advanced medical directive. Mm-hmm. Can you tell me what that is?
Sure. Advanced medical directives are essentially documents where you're trying to designate people who are going to be responsible for making medical decisions for you in the event that you're unable to do so. So we create a document at our law firm that kind of combines a handful of documents. One is the living will, which is essentially going to designate what kind of treatments you want in the event of your last and final days. So for example, we've talked about the Cherry Shivo case a lot, where you have decisions to make as far as whether you want to be kept alive artificially. Your living will says it can or cannot say, depending on what your wishes are, that you do not want to be kept alive artificially when you're in a terminal or end-stage condition. Whereas it's definitely, you can differentiate between that and a do not resuscitate, because in your living will we're talking about situations where you're not going to recover. You're never going to get back to 100%. You are either in a vegetative state or you're in a terminal condition. So oftentimes people misconstrue what the living will does and what it's for. It's not a DNR. It's basically when you're at that end stage. So the other part is the healthcare surrogate. You're naming an individual to make medical decisions for you in the event that you're unable to do so. So the common example we tell clients is you are in a car accident, you're in a coma. You can't make those medical decisions when the doctor has those tough decisions. Do we want to do this surgery? Do we not want to? Your healthcare surrogate's going to step in your shoes and they're going to make those decisions for you.
Okay, so who's typically appointed as the surrogate to make those decisions for me?
Well, there's no requirements, and I'll jump back as far as the personal representative goes with your will. There are requirements by Florida law. They have to be either a blood relative, or if they're not, a resident of Florida. And so, when Annie talked about naming a fiduciary like an attorney or a CPA, they have to have business priorities in the state of Florida, whereas if you're dealing with family members, there's no issues. When you're dealing with your neighbor from your old place, everyone's a transplant here in Florida. When you're talking about your best friend next door, that's not going to work here in Florida. Your healthcare surrogate's much different. You can name anyone you want. In our situation, given our background and the history that we've worked with these documents, we've learned that you ultimately want to name someone who understands what your unique circumstances are and the desires that you have when those times come. You want to know someone, if you're not going to recover and you don't want to have those extra treatments, you want to have someone that can say, no, we're not going to do those procedures. So family members obviously are great because they're your blood and they know what you ultimately want. But ultimately you want to pick someone that will do exactly what your wishes are.
Okay, so that's my advanced medical directive, and somebody's appointed to make medical decisions for me. What about when I can't handle my finances?
Sure. Great question. There's another document. It works just like the healthcare surrogate. It is called the durable power of attorney. So you're naming someone to handle your finances in the event that you're unable to do so. We tell clients, again, there's no requirements as to who they are. Ultimately, they need to be residents of the state because your transactions are done here. Family members can work, but again, just like Annie pointed out, it's someone that you trust. It's a trust issue. They're going to have access to your finances, and you're going to be, again, in that situation where you're in a coma and you can't do things. So it's someone that has to be trustworthy.
All right, so my daughter is very, very trustworthy. Why don't I just put her on my bank account and forget about this document?
Great question. Now, there becomes another variable. Naming joint owners on your account is sometimes a good thing because they can access the account when you're unable to. However, you're throwing in opportunities for things to go wrong. For example, if your daughter was ever in a divorce or if she had a lien placed against her, those are things that can affect your bank account that you didn't intend or anticipate. So it's, there's a financial obligation associated with naming someone else on your account because they are indeed an owner just like you.
All right, so bad idea?
I always tell clients it's case by case, but ultimately we prefer not to do that. That's why you have a power of attorney in general. So if you can't do it, someone else will do it for you.
Okay. So another question that always comes to mind is, what kind of taxes have to be paid? Once I die, do my kids have to, if they're the beneficiaries, do they have to pay a whole load of taxes out of my estate?
Sure. Well, it depends. There's no inheritance tax here in the United States. There is, however, what's called an estate tax. It kind of works the opposite way. So when you die, everything that you own, all of your assets combined, if they're above $5.45 million, then you are going to have to pay a 40% tax rate, roughly, on those assets above those. So if you're under that threshold, then you're fine. You're not going to have to worry about taxes. There's no state estate taxes in Florida, as there are in other states, so you don't have to worry about that either. That's the beauty of Florida, beyond the sunshine, of course. And so you're not, a lot of our clients, we've run into a much smaller amount of people who are running afoul of these estate taxes because the exemption is so high and it's set to continue to rise.
All right. Annette, I'm going to address something to you. Recently, I moved from the state of Colorado. That's where I was a resident for 25 years. I did all my documents there, my will, my power of attorney, my medical directive. I'm a resident of Florida now. Do I need to redo those documents?
Well, we tell our clients who recently moved and became Florida residents, it's always a good idea to come in and have your documents reviewed, because 9 times out of 10 there will be an issue because Florida has such unique administration laws. And so you just want to make sure that your documents are Florida statute compliant with Florida statutes. So,
all right, well, that's interesting. I'll have to get in to see you guys. Let me just moving forward. Now I'll play devil's advocate because I have to put you guys on the spot.
Sure.
Hey, I've gone online. There are these places where I can pull up all these documents. I can do my own will, my power of attorney, my medical directive. Why do I need an attorney?
That's a great question, and I will be the first to tell you I was asking the same question myself. So I got online and I tried to prepare documents for myself on the online accounts. Now, as Annie mentioned, every state is unique. We have unique laws that you have to comply with in order to be protected as far as your documents go. The online law forms are blank documents that you fill in yourself, and if you look on the websites, they have a disclaimer saying they're not attorneys. So you may put this document together, think you're in good shape, but there's no guarantee that it's going to have the state essential parts to the document, and there's no guarantee that you'll execute it properly. There is an execution process that you have to go through in order for your documents to be valid. So there's a lot of pitfalls to it. It may save you some money, but it's just like anything, you get what you pay for.
Right. Okay, so I have all my documents in place, and I've got them. I take the originals home. What do I do with them?
It's a great question too. It's preferential to the client. In our firm, we recommend us holding the will in our vault files for the client and sending them home with copies. The reason being is if it gets lost or destroyed, it bogs down the administration process, and it's essentially slowing down the distributions to your family members. Having the will in our vault, as soon as we find out something's happened to you, we submit it to the court. It's there with the clerk's office, and it's recorded, which is the most important thing. You have 10 days to record it. So,
all right. So next question. Can I change my will? What if I want to leave somebody out who was in my original will? Can I go back and do that?
Yes. You are free to either execute a codicil to your will or execute a new will at any time. So if things should change in your family, say there's a new birth and you want to include a grandchild, or something happened and child divorces, or any family change, then you can come in and you can either re-execute a new will or you can amend it by executing a codicil.
Okay, so a codicil is just an amendment to...
Yes.
All right. So how often should I be looking at my documents? I mean, a lot of people, they get their estate planning documents, they put the copies in a closet, in a file, and don't look at them ever again. Should I be reviewing these from time to time?
Yes, it's always advisable to just review your estate plan every 3 to 5 years, but maybe sooner if there is any big life change. So that's typically what we recommend.
Okay. All right. So I want to ask you, what sets Isfording, Bechtold, and Scherer apart from the other estate planning attorneys in this area?
That's a great question. I think the best answer is we are extremely personal. We don't do cookie cutter documents and make people fit into the documents we have. We make them tailored individually to our clients, and we want to get to know your family. We want to make sure that we're doing everything the right way, so when the time comes and we have to execute those documents, it's exactly what you want. It's not what you thought you were getting, essentially. So we want to make sure that we know all the dynamics with your family. And so the other thing is we do free consultations with clients. When you talk about you have Colorado documents, we review those for free, and if we don't have to make any changes, we're going to tell you that. We're pretty honest. We do our best to make sure you're satisfied, and that's our biggest thing. Our client base mostly comes from word of mouth, and it's from prior clients saying how good of a job we do, and so our integrity is of utmost importance, and so I think that's what sets us apart from a lot of the estate planning attorneys in the area.
Well, I thank you both for being with us today. Brady, Annette, it was a pleasure. Very, very informative for our viewers. So that is all I have today from the Elder Care Channel in Sarasota County. My name is Mary Ann Gordon from Home Instead. Until next time.